Good morning. This is the time set for argument in Johnson versus Edelstein. Each side will have 20 minutes. We have read the pleadings, the briefs, and we look forward to hearing your arguments. If you would announce your name and who you represent when you begin, it would be helpful so we can have it for the recordings. These proceedings are being video and audio recorded. If you'd announce who you're representing when you begin, that would be helpful. And with that, counsel, you may proceed.
Good morning. May it please the court, my name is Spencer Schieffer. I represent the petitioner, Michael Johnson, in this special action. For consistency and so we can all follow along, I will refer to my client as Johnson. I will refer to respondent Andre Daniels as Daniels and respondent Makisha Dennis as mother. This case stems from the trial court setting aside an acknowledgement of paternity signed by mother and Johnson shortly after the birth of the child at issue in this case, known as AD, which the acknowledgement of paternity had been established and signed and filed on December 26, 2017. The acknowledgement was set aside in favor of a subsequent paternity order that was entered by the trial court in 2020, which was derived from a petition filed by Daniels in November of 2019, nearly 2 years after the acknowledgement of paternity had been signed and filed. The trial court set aside the acknowledgement basically on two findings. One, that the mother had avoided service of a petition filed by Daniels in 2018, and two, that Johnson did not sign the acknowledgement voluntarily. Based on the evidence, those findings are not supported and or they are not consistent with Arizona law, and therefore the trial court's ruling should be reversed. First, I want to talk about avoiding service. The trial court found that mother had avoided service of a petition filed by Daniels in March of 2018, essentially on the basis of a very small amount of testimony to the effect that Daniels testified that he had hired a process server to serve mother with that petition. The process server contacted her, arranged a date and time to meet, and mother did not show up. However, the record is replete with testimony and evidence demonstrating that mother and Daniels continued to have significant contacts with one another during the time period after the petition was filed up until it got dismissed. Those contacts included not only contacts for sexual contact to further their sexual relationship, but also exchanges of the child AD himself. During any one of those exchanges, Daniels knew where mother was residing or knew where she would be. He had the opportunity multiple times to arrange service of the petition on her, but failed to do so. In addition, under the rules, he could have filed for alternative means of service or even service by publication, which I believe is what he did after filing the 2019 petition, is he filed for alternative means of service. So he knew how to do so, or should have known how to do so as a self-represented litigant. Based on those facts, the trial court abused its discretion because it's beyond a stretch to find that mother had avoided service of a petition when she was in fact having multiple contacts with Daniels, and the testimony demonstrated that Daniels not only knew where mother resided at the time that AD was born, but also knew where she resided and had gone to her residence in 2018 after she changed residences.
Counsel, let me ask you, what if, hypothetically, because I know that's not your argument, you just told us your argument, what if the trial court was right in finding that mother had dodged service, had evaded service successfully? What would your argument be?
So even then, and that's exactly where I was going, just the hypothetical, even then, the court would not have legal authority to set aside the acknowledgement. So what is avoidance of service? So under the statute and case law, there's basically three ways to set aside an acknowledgement of paternity. 60 days to rescind under the statute by the parties, or fraud upon the court, which is limitless, as established in Alvarado v. Thompson, or under the statute 25-812E, which is under Rule 85C and pursuant only to fraud, duress, and mistake of fact. So at best, even under the most generous interpretations, if we equate avoiding service as fraud or well, I don't think it really can be equated to duress or mistake of fact, but let's say it's fraud. Even then, under the statute, under Rule 85, the timeline of when you can set aside acknowledgement of paternity for those bases, fraud, duress, mistake of fact, is limited to 6 months. So the acknowledgement was signed and filed in December of 2017. So at 6 months, that would have expired in 2018. The petition that Daniels filed was dismissed in late 2018, and he did not refile until November of 2019. So even then, if we agree that the trial court was correct that she had avoided service, the statutory framework and legal authority to set it aside did not permit it under that basis.
And is fraud upon the court, you mentioned that in passing, is that an issue in this case?
So fraud upon the court is not at issue. The trial court did not find fraud upon the court, and Daniels agreed in his response that the court did not find fraud upon the court. So without supporting evidence and because of the current case law, the trial court really had no legal authority or basis to set aside the acknowledgement on the basis of mother avoiding service. Next, the court also set aside the acknowledgement on the basis that Johnson did not sign the acknowledgement voluntarily. In effect, what the trial court reasoned was that because Johnson did not know that mother was having a side sexual relationship with Daniels, and he did not know that Daniels potentially could be the father, and did not know that mother was also telling Daniels that he might be the father, that he could not have signed it voluntarily. Now, the trial exhibit that was submitted, the acknowledgement attorney, it clearly has the statutory language of explaining the risks of the risks of signing the acknowledgement, which Johnson did sign. And really what the trial court is getting at is saying that either Johnson made a mistake because he didn't know, or there was fraud committed on him by mother by concealing or withholding information about alternative potential options for AD's fatherhood, paternity. So those two things are bases under the statute to set aside an acknowledgement of paternity, mistake of fact or fraud. However, again, as I just explained, under the statute, the time limit to do so is a 6-month window. So even if the court is correct in saying that Johnson made a mistake of fact or was defrauded by mother about this information when he signed the acknowledgement, the time limit for Johnson or even the court to legally set aside the acknowledgement of paternity was a 6-month window. And at this point, this was instigated from the litigation by Daniels' 2019 petition and or the 2020 motion to intervene that Johnson filed. That 6-month window had long passed. And I want to emphasize for a minute the significant negative impact that the trial court's ruling, if upheld, will have. Essentially, what the trial court has done is create what I call a had I known legal principle here. The trial court is saying, had Johnson known that there was another man, had Johnson known that mother was telling someone else that he was the father, had Johnson known that she was having a sexual relationship with another man, he wouldn't have signed the acknowledgement. And the trial court treated it as this limitless window as to when he could set aside, or when the court could set aside, the acknowledgement of paternity. Under that framework, the case law that has explained the narrow window, the extremely limited circumstances of how and when an acknowledgement of paternity that is signed and filed can be set aside completely goes out the window. And it creates a framework where any father who has signed an acknowledgement of paternity who happens to not be the biological father can at any point in time during the child's minority to set aside that decree by filing a motion and basically saying, had I known, I was not the biological father.
Counsel, but there's no denying that Daniels is the biological father in this case, correct?
That is correct.
Okay, so with that in mind, what do you make of the Brummond case, Brummond v. Lucio? Right,
and so that is the case that Daniels is relying upon, it seems, most heavily to affirm the trial court's decision. I believe and contend that Brummond cannot be reconciled with this court's decision in McQuillan v. Hufford. So in Brumman, for the first time, the trial court, or the Division II, held that there is no time limit to when a biological father can come in and assert paternity. Now, importantly, the analysis that the Brumman court had is inconsistent with the analysis in Brumman, the analysis in McQuillan. In Brumman, the mom signed an acknowledgement of paternity with her boyfriend. About 2 years later, similar to this case, the biological father came out and filed a petition to try to establish paternity. At trial, the trial court thought that the father was time barred, asked for a briefing on the matter. After briefing, the trial court ultimately held that the father was time barred. On appeal, Division II reversed that and held that the father was not time barred and that there was a never-ending window for him to come and assert paternity. Now, more specifically, what the court did there is they treated the acknowledgement of paternity not truly as a judgment, as it should be under the statute. They treated the acknowledgement of paternity as a mere presumption of paternity under the statute 25-814. And so what the court there held is that the trial court should have taken the acknowledgement of paternity and the DNA test that was in that case as competing presumptions of paternity. And because they were competing presumptions, the trial court should have determined which one should control based on weightier considerations of policy and logic. And then presumably the trial court could have created a paternity judgment based on that DNA test. And then under 25-814C, that DNA test would be a judgment that would rebut the presumption of the acknowledgement of paternity. That is the exact argument that the mother made in McQuillan v. Hufford. She argued that the trial court should have weighed these two competing presumptions. And the court in McQuillan explained under the statute that that is not the case because the acknowledgement of paternity is not a mere presumption. It is a judgment. So under 25-812D, a signed and filed acknowledgement of paternity is treated as a judgment. And as a judgment, as explained by the court in McQuillan under 814C, that is the judgment, that is the court decree that rebuts other presumptions, including the DNA test. So the court in McQuillan explained, unless you have a legal means and authority to set aside that judgment, we don't even get into the DNA test and weighing that against an existing judgment. As the court explained, there is no presumption of paternity that makes sense because the child already has a legal father who was established under the acknowledgement of paternity. So in essence, the court in Drummond and the court in McQuillan have incompatible viewpoints and interpretations of the statutes, specifically 25-812D and 25-814C. In Drummond, the court was not treating an acknowledgement of paternity as an actual judgment. It was only it called it that, but it only paid lip service to it. It was treated as a presumption that could subsequently be set aside purely on the basis of a subsequent DNA test, subsequent order based on that DNA test to then set aside and get rid of the pre-existing judgment being the acknowledgement. And on that note, if the holding and reasoning in Drummond is allowed to continue and is upheld to affirm to the trial court's decision in this case, it creates a similar scenario of what I just explained of the never shutting window. Under Drummond, a biological father can come in at any point in time during the child's minority, and a child's stability and permanency is never safe under an acknowledgement of paternity. A biological father can come in at any point and bring in a DNA test and then have that compete with the pre-existing judgment, acknowledgement of paternity, and then create a paternity judgment that then overrides the acknowledgement of paternity without any other legal authority that's been established by Alvarado or other existing case law under the statute 25-812E. And that would create a scenario. So let me paint the picture further. The husband or the father in McQuillan v. Hufford was quote unquote successful at not having paternity established on him. He didn't want that, even though he was the biological father. Under Drummond, that same person could come back 10 years from now with that same DNA test that was used in McQuillan v. Hubbard and say, oh yeah, I am the father. I want to be the father now. And he could use that, and under the reasoning and rationale in Drummond, he could have his paternity established and disrupt that child's father-child relationship over the last 10 plus years. So because I believe and contend that McQuillan accurately interprets the statutory framework in its entirety, that is what should be followed, not Drummond v. Lucio. And so because of that, I do not, the trial court's holding and ruling should not be affirmed on the basis of Drummond v. Lucio. And just to go back really quick on the voluntary nature of Johnson signing the acknowledgement of paternity. There was no testimony elicited from Johnson about whether or not he would have signed the acknowledgement had he known. And I think that his actions in this case demonstrate that he absolutely wants to be AD's father. And that even after learning from Daniels and his action that he filed and the paternity test that he submitted in this case, even after knowing all that, he is still here wanting to be AD's father. So I don't think that can be questioned as from a factual standpoint, and more importantly from a legal standpoint. The court really did not have authority to kind of do this semantic loophole, as I coin it, to treat either what it would be a fraud or a mistake of fact as termed in voluntary or involuntary signing the acknowledgement of paternity. He absolutely signed it voluntarily in front of a witness, and that has not been questioned. So in conclusion, the trial court's findings, the two of avoiding service and Johnson signing the acknowledgement voluntarily, are not supported by the facts and or the law and should be reversed. In addition, the Brahman case that Daniels presents to try to salvage what the trial court has done is also inconsistent with the court in McQuillan, as well as the plain reading of the statutes 812D and 814C. And therefore, that should not be the reason or basis to affirm the trial court's ruling. And based on these things, we request that the court grant the petition for special action and the relief requested therein, and primarily vacate the paternity judgment that was entered in 2020, naming Daniels the father of AD. I'd like to reserve the rest of my time for any rebuttal. Thank you.
Thank you.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the real party in interest, Andre Daniels. In my response to the petition for special action, I had asked the court to decline special action jurisdiction. But now that we've gotten this far, I have a feeling that issue might be moot. And for the sake of the parties, too, there's an appeal pending. I think I'd like to ask the court to accept jurisdiction, but decline the relief requested, because the Brumman case is right on point. It's on all fours, as we say. It's dispositive of the issue of when the biological father wants to challenge an acknowledgement of paternity and establish paternity in his own child.
And there's no limitation on when that can happen?
Well, the statute on paternity actions is conclusive on that, and I believe it's up until the child reaches the age of majority under ARS 25-803, 804, I believe it is. So there would be a limitation, but just because that he can file this paternity action doesn't mean he trumps the acknowledgement of paternity. Remember, you've got two competing presumptions here, and so it's up to the trial court to exercise its discretion to determine based on the facts.
Counsel, is it really a presumption, or isn't an acknowledgement by statute have the force of judgment?
It has the force of judgment, Your Honor, between the parties to the acknowledgement of paternity, but it does not in regards to the biological father. That's what the Andrew R. case said. We're not making a decision as far as biological fathers are concerned. And that's when Brumman came in and said, we're going to answer that question now and say no. The acknowledgement of paternity does not have that same binding effect on the parties to the acknowledgement as it would have on the biological father. And so the biological father has two options. He can pursue the 25-814E remedy, or 812 remedy, I'm sorry, of filing a motion to set aside, or he can file a separate petition for paternity. And if you look at the statute reads, a party may proceed under Rule 85, and a party is inclusive of biological father. I'm not arguing that it doesn't apply. But he has the option of either going under that Rule 85 procedure, under 25-812E, or he can file the petition for paternity, as Brumman says, under 803, 804 of the statute.
And counsel, your position is that that would obtain through the age of majority for the child, regardless of what information the biological father knew and regardless of when the biological father knew that?
No, I believe it only pertains to an innocent biological father. As Brumman points out, father didn't know that the child was born or didn't have any contact with the child whatsoever. And in that situation, being an innocent party, he has a right to establish a relationship with his child as a parent. It's a constitutional protected right under the Lair versus Robinson case that's cited in Brumman.
But how long can he wait? I realize there's an allegation that someone's avoiding service, but if you just wait, there's no responsibility to provide child support. You just kind of leave that in your back pocket. Can you just wait 5 years, not be responsible for any child support, and then 5 years down the road, yeah, I'd like to make this official?
No, because in that case, he's not established a relationship with the child. The Lair versus Robinson case says it's not just because of a biological link that he gets to establish paternity. He also has to have some kind of a relationship with the child. So if he sits and waits for 5 years and he knows that the child's been born and he doesn't take any action whatsoever, the court's going to balance those interests when it considers.
But you do take some action, but you don't take any. Let's say there's no financial responsibility or no just taking some responsibility. Just hypothetically, maybe 1 day a month for 5 years. At that point, you can come in and say, yeah, it's time now. I want to become the father.
Yes, but the statute also allows for arrearages for child support. It's not like he's going to get away with it by waiting. The statute does provide that the court can assert arrearages for that father for the 5 years or so that he waited and didn't provide any sort of support. But he has to establish that relationship. And in the situation where the mom is hiding the child away from the father, not allowing that parenting time to be established, or he has no idea that's what's going on. That's what happened in Brumman, where he decided he wanted to come forward and determine if he's the father, because mother didn't tell him any information about it. There's no way he would know that that child is out there. So I guess the situation could occur that it could be 5-10 years later, but he still has that right to establish that paternity relationship.
Is that the facts pattern that we have here, counsel? That
No,
the
and
mother
that's-
had kept all knowledge from Daniels?
No, in this situation, we have a father who was involved with the child. The mother did allow some visitation, and then she withheld visitation. So it was kind of an on-again, off-again petition for paternity that he filed. The first time he stopped because she was avoiding service, but the second time they did accomplish service, and that's when the DNA test was made. And that's something we don't have in this record, why the DNA test was ordered, except that it was done by stipulation. So that argument about you have to have the acknowledgement set aside before you can do the paternity testing kind of falls by the wayside, because in this situation there was a stipulation to do the DNA test, and that established that my client was the father.
Was that the first DNA test that was ever done?
No, apparently my client had done a DNA test prior to the time the acknowledgement of paternity was entered into. I believe it was in November of 2017. But he kept those results to himself for some reason. I can't explain why. But he just wanted to be assured that he was the father because he knew mother was having relations with other men. But he didn't know specifically that Mr. Johnson was the other potential father. And he didn't know about the acknowledgement of paternity.
What role does the best interest of the child have in this case?
Well, as far as determining paternity, I believe the cases say the best interest doesn't come into play. It's not until the placement, once the paternity has been established, that the placement of the child brings in the best interest test. and that's
Doesn't-
Stevenson versus Nastro.
With minor children under Hayes versus Gama, doesn't best interest sort of permeate Title 25%?
Yes, and although the statute talking about weightier considerations of policy and logic doesn't specify best interest, I believe at that point in time, a best interest analysis would be appropriate.
And I guess what I'm thinking about even more so is the hypothetical that we're talking about 5 or 10 years down the road, if Grumman sort of will serve, that a child's placement, a child's life could be completely turned upside down.
That's true. So it would be a best interest analysis, I would imagine, under those policy considerations. Because, yeah, you're the biological father, but you haven't had contact with this child. You haven't supported the child. I think in that case, Grumman would result in a finding that the acknowledgement of paternity is going to supersede the genetic test.
I think, though, under your position, it could result in that, but your view is that's a discretionary call, right? So effectively, not maybe technically or practically, but in most cases, effectively beyond bounds of an appellate scrutiny.
Right. I think a biological father should have that chance if he's been denied access to the child, been denied knowledge that an acknowledgement of paternity exists, that somebody has signed away his rights to be a father, has under Grumman the right to challenge that constitutionally.
Sort of bringing back to the facts that we're presented with today, where it's kind of a clash of absolutes. And the trial court, I think, acknowledged in the decision that we're asked to review, what are we to make of that first petition for paternity that was abandoned?
What are we to make of it as far as res judicata or something?
Well, it strikes me that, to the extent there was any doubt about knowledge of biological paternity, it was known before then, perhaps long before then. And here we are sort of literally years later. I think that was filed within the time frame.
Within the 6 months, yes.
Right. But it didn't sort of come to conclusion.
No, the father testified that mother was allowing him the visitation or the parenting time, and so he decided not to pursue it.
Does that obviate the need to define? I mean, presumably there was a birth certificate out there with somebody's name listed as the father. I think that paternity action was to either insert a new name or change that, but it was then abandoned at a time that could have avoided all of this.
Well, again, father wasn't aware of that birth certificate, and yes, he wanted to establish paternity at that time because mother was denying him access to the child.
But isn't there some, I mean, if his name was on the birth certificate, there's no need for that action, correct?
Right, but he never saw the birth certificate or the acknowledgement of paternity. See, mother was keeping this information from both gentlemen, apparently. So why should it be held against my client that he's left out of the loop? And because he filed that first petition, I don't think that would supersede him filing a second petition once he gave up on her withholding the visitation and parenting time.
Provided, and again, that's what we're asked to decide, that it was time, right?
Yes, sir. Yes.
But at some point, how long, in your view, I mean, at some point, would it be inequitable, or if he had waited 4 years, and even though he'd done a paternity test and knew that he was the biological father, can he wait 4 years and come in? At what point would you say there's any time limit, time frame within which he had to come forward?
No, I'd say there's no time limit because there's nothing in the statutes to talk about a time limit to establish paternity other than the age of majority. And so it's up to the court to exercise its discretion to determine best interest, policy considerations, whether this father who has a DNA test has the right to custody or parenting time with the child. If he waited too long, I would say the court's going to rule against him. But he should still have that right to file that petition because there's no time limit. There's a time limit under 85C, and as the Brumman court pointed out, the court could have denied his 85C motion because the 6 months had elapsed. But there's nothing in the statutes that prevent him from filing a separate action for paternity. 10 years from now, 20 years, well, it couldn't be 20 because it'd be past the age of majority. But in any event, he would be entitled to file it, and he would raise these policy arguments. Well, she ran off with the kid and I didn't have a chance to establish a relationship. Versus, well, you didn't pay any attention to the child. We're not going to give you parenting time or custody. So it's a battle of these presumptions under 814C. This is an 814C case, 25814C, that talks about when you have competing presumptions, you have to make a consideration of policy and logic. And that's what Judge Edelstein did here. She looked at the fact that mother was avoiding service. By the way, that's a factual determination. This court's not going to question the credibility of the parties. The judge believed father when he said that the process server had tried to contact mother and she wouldn't cooperate.
Counselor, are you aware of any other situation in the law, anywhere, where something that is treated as a judgment, like the acknowledgement is simply entitled to a presumption as opposed to permanency or finality? I am not, and so, but I wondered if you...
That's a good question. No, I'm not. But our paternity statutes are unique because under 25814A through 4, I think it is, acknowledgement of paternity is called a presumption at that point. The DNA test is a presumption. The birth of a child during the marriage within 10 months is a presumption. And even the acknowledgement is listed as a presumption under 814.
But this has gone beyond a presumption. When there's the birth certificate and the time has passed, I mean, there is a father, and that person can't just walk away at that point.
Exactly. That's what that permanency issue is all about. The courts of the law doesn't want a father who acknowledges paternity to say, no, I changed my mind, I want out of here. That's part of the permanency argument. Not as far as the biological father goes, though, because the biological father, again, is the innocent party. He had no knowledge of the acknowledgement. He's entitled to file his paternity action under the statutes.
But he can just kind of leave it in his back pocket. Okay, well, now I'm getting some parenting time. I don't need to make this official. If I decide down the road that this isn't working out, I just won't pursue it any further.
I think he would have to make it official if he found out that there was an acknowledgement of paternity where some other father was out there. At that point, he has knowledge now. He has notice. So to answer your question, that notice thing, that knowledge would trigger him having to file something to establish his paternity.
So, and you mentioned the presumption statute and the treatment of an acknowledgement as a presumption. As I read that statute, there's no requirement that such acknowledgement be filed at that point. Isn't that correct?
The acknowledgement to be filed, it's filed
in
with
order to
the
constitute a
health.
presumption.
As I understand, the acknowledgement has to be filed with the Arizona Department of Health Services to become a presumption and to become a judgment as well. So under the statute, you're asking if it's not filed, is it still a presumption?
So, as I read that statute, there's no requirement that an acknowledgement actually be filed in order to constitute a presumption. So are you saying that
I see what you're saying, yes.
that an incompleted process, someone signs an acknowledgement but then does not file it with one of the recommended state agencies?
Right.
Okay, that should have the same force and effect as one that has completed that process, filed it with those agencies, with which anytime you file anything is intended to give notice.
Right.
So,
I think the McQuillan court made that distinction, saying that if it's not filed with the registering agency or with the clerk of the court, then it's not a judgment yet. It's only a presumption at that point.
okay, so then your references to the balancing of presumptions, and this is only a presumption, or an acknowledgement only constitutes a presumption, is that not inconsistent then with that determination, that distinction that was found in McQuillan?
No, because again, the biological father was not a party to that acknowledgement. My interpretation of the law, I don't know if the court's going to agree with me or not, but my interpretation of law is that it's a judgment pertaining to the parties who were signing that acknowledgement of paternity. But again, with an innocent biological father out in the woods, not knowing what's going on, that judgment doesn't bind him. It's not res judicata as to him. We wouldn't give it full faith and credit if there wasn't personal jurisdiction from another state. So for the same reason, that judgment, even though it was filed, should not have any res judicata effect on a biological father. I think that's what the Brumman case is saying.
But,
You're taking away a constitutional right.
but in the beginning, weren't we talking about whether or not notice, and if you had to come to that, Brumman says you have to come to this as an innocent party. McQuillan says this as well.
Right.
So you can't know that something is going on and then sit on that right and then expect the court to be able to overturn those, particularly a final judgment. You agree with that, correct?
Right. Once he knows that there's an acknowledgement out there, he's got to do something about it.
Okay, so in terms of those types of interests, don't we find in the law replete those sorts of constructive notices that happen with the filing at state levels that people are charged with knowing? The putative father registry, for instance.
Sure, you're talking about an adoption case, and Brumman points out that the adoption registration wouldn't apply here, that there's no requirement to register an acknowledgement of paternity. And so father doesn't have constructive notice, bio father. So we can't make that analysis or that similarity in the argument of constructive notice because there's no registry that he can go to see if somebody else has signed up as the father of this child.
Did not Mr. Daniels acknowledge that by filing his first paternity action in 2018 that paternity of the child was not really set?
Right, that it hadn't been established as his position.
Okay.
That's why he filed it.
And yet walked away from it
Because
and let it not resolve.
Because mother hadn't told him there was a competing father out there. Mother was allowing him visitation, parenting time. And I could see from his point of view, I rocked the boat. Things are going fine. I'm seeing my child. I'm supporting my child. Maybe I don't need a court order. But then things got rough again, so he decided to pursue it a second time.
So even if there are applicable registries that give the public notice of these things, your argument is that that constructive notice does not apply, and a biological father has an unlimited amount of time during the minority to come forward and establish this paternity, regardless of an available registry that someone could look at that would say, this person has already acknowledged paternity.
Correct. If there was such a registry, I would agree that he would have constructive knowledge. But this isn't an adoption case, and so there's no registry that he could go to.
When someone files that acknowledgement with a state agency, do you know if records are maintained about that filing?
I'm sure they are, yes, sir. But they're not published. They're not, I'd kind of like to see what the rights and responsibilities are listed in the acknowledgement. When the parties sign it, the statute requires that they be advised of the rights and responsibilities. I would hope that it has something in there that says, by the way, the biological father might come in sometime and set this thing aside. That would give them notice at least to let other people know that this acknowledgement has been entered. But again, mother didn't do that. And even Mr. Johnson, I believe, when he met with my client, before my client signed filed that second petition, never produced an acknowledgement of paternity, just said, I'd like to raise the child, but didn't say that, hey, by the way, I'm the father. What are you going to do about it? So, again, it's an innocent father here, the biological father, who has a constitutional right to raise this child, who had contact with the child, and under my interpretation of law, the trial court did the right thing. My time's expired unless the court has any other questions. Thank you, Your Honors.
Just a few items I want to address. Actions have consequences, and lack of action has consequences. Under the statutory framework, Daniels had an opportunity to assert paternity. I believe the record demonstrates that mother told Daniels that she was pregnant and that the child might be his. Under the statute, he could have filed a petition for paternity even while the mother was pregnant. And under the statutory framework, to protect and assert his paternity rights, he has up to, at a minimum, 6 months from when the child is born and a potential acknowledgement of paternity is signed by another man to file a petition for paternity and assert his rights. The acknowledgement of paternity was signed and filed end of December. He filed his petition for paternity in 2018 in March. So that was within the 6-month time window. That was his opportunity. That was his action where he could have used that DNA test that he said he took in 2017 to confirm that he was the father, but never told anyone about and didn't submit with the petition, and he could have used that to establish his paternity and set aside the acknowledgement based on mistake of fact. He chose not to do so because things were comfortable and because things were going well. He chose to abandon that action and forego his legal right and his legal ability to establish his paternity. The problem with the Brumman Court is, I think has been discussed, there's no limiting factors. There's no end time as to when a biological father can come in and disrupt the child's permanency and stability. He can do it at any point from when the child is born until they're 17 years old and a day to try to come in and disrupt that child's known parent-father relationship. And I don't think that, although it may be implied that the court's determination between weightier considerations of policy and logic may include the best interests of the child, but nowhere that I'm aware of is best interests of the child legal means to set aside and void an existing judgment, which would be an acknowledgement of paternity. And I think my position is clear as far as the legal.
What if there were an affirmative misrepresentation that there's no one else who is listed on the birth certificate? Would that change your analysis at all? I'm sorry, I didn't quite follow the. I think in what you're suggesting is there was no reason to know. Well, I guess what biological father is suggesting, there was no reason to know that there was someone else had been listed on the birth certificate. And if there's an affirmative misrepresentation that there is no one on the birth certificate, would that change your analysis?
Meaning that, say, mother told Daniels, there's no other father.
Right.
I guess I suppose that would be a fraud that mother had committed on Daniels, and that would be the basis to set aside any acknowledgement. But again, that's a 6-month window. I don't think that rises to the level of fraud upon the court, as that action and that interaction doesn't involve the court or involve the signing of any document. And so I think that would give rise to fraud, but not beyond the 6-month window. As far as the timing, in the adoption context, action has to be taken. A father has to file with the putative father's registry within 30 days. If not, he could risk that his child will be adopted by some other person. In the paternity context, he has to take action. He has 6 months from when the child's born, or potentially longer if an acknowledgement's not signed and filed until sometime after the date of birth, but at least 6 months from the date of birth, which he can take action and assert his paternity. So he has, any biological father, including Daniels in this case, has and had ample opportunity. And Daniels is different from the father in Drummond from a factual standpoint because he wasn't an innocent party. He had actual knowledge. He had a DNA test that he took ostensibly and kept to himself. He filed an action. He just chose not to see it through.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we'll have a short recess.